All right, we're back and live with the final session of the day. We've got Lane Fisher and Joe Dunn here just talking to us about some legal challenges and issues that are facing the home services industry and franchising. And I'm going to be stepping in and joining as well, having had my own fair share of experiences in this category. So with that, I'm just going to remind everybody, on the very far top right of your screen, you'll notice there's a feed in there. You can chat at any point in time. And then to the right of that is your Q&A area. So this is your chance to go ahead and ask any questions you may have of Joe or Lane around legal issues facing home service franchisors and not be sent a bill until later. So thanks, Lane. Thanks, Joe. Lane, it's your show.
Well, thanks, Scott. I appreciate you having us, and I note our timing at the after all, everyone's all fired up about selling. All your sessions are now over. Bring the lawyers in. Disconnect everybody. This is the bad now. No, we're elated to be here. My name is Lane Fisher. I'm a partner at FisherZucker in Philadelphia. We have the good fortune of representing some 250 brands. I also serve on the IFA board of directors and FranNet board of directors. And as Scott mentioned early on, I am a co-conspirator with Brad Fishman in the Springboard, Unconference, Young Conference, and whatever other conferences we haven't thought of. And Scott, we very much appreciate your kind words about the genesis of this event and the folks that you met over the years at our events. We are excited to be here. We're excited about the performance of service brands, the liquidity in the market for home service brands, and some positive signs of recovery that we've seen from some brands. To some extent, it's the bright light in the offing, and I guess some could say home services are really cleaning up. It's so hard to do anything funny on this. All right, so,
is it to get better?
Yeah, only from here it gets a lot better. The jokes get better.
That's what I miss from being in the office.
Yeah. So as Joe points out, we are still working remotely. We're still not permitted to go into our office because our work can be done remotely. So we are joining you from our respective homes. Notwithstanding not being in the office, we are still peppered by these issues on a daily basis. And I have brought for you, for show and tell, the large brain of Joe Dunn to share with you on some of these highly technical issues. Basically, as you all know, the traditional business model used by home service franchisors is facing increasing pressure from new laws, regulations, and activist lawyers. This program will discuss the choice between independent contractor versus an employee model in light of misclassification claims, California's AB5 law, and similar ABC tests across the country. Joint employment is set for a big federal comeback in the new Biden administration as we expect the NLRB to reassert theories of joint employment found in the Browning-Ferris decision, and the Department of Labor to continue to depart from its classical employment test of control in favor of the economic interest test we saw in the late days of the Obama administration. The panel will also discuss the impact of how the pandemic on how home services are delivered and the health and related legal concerns of both workers and customers. And finally, the panel will discuss the impact of the new home income recognition rules and how it impacts franchise sales. I have an amazing panel. I'm going to ask our panelists to introduce themselves with a short introduction. Joe, why don't we start with you?
Sure. Joe Dunn. I am a partner at FisherZucker, working primarily with franchisors in navigating their regulatory and transactional matters.
Well, thanks, Joe. Good to have you. Good to see you.
Lane.
Let's see, Jeff Wall.
Hey there. So my name is Jeff Wall. I am the CEO and president of Handyman Connection. My background, I spent 30 years in the home services franchise. I used to be a franchisee a long time ago with a company called College Pro Painters, and then spent 15 years full-time with College Pro. Ended up as the president of that company before moving over to a sister company at that time called CertaPro Painters. Spent a couple of years over there and then moved over to Handyman Connection. All of those companies were owned by a company called FirstService or FirstService Brands. And then I purchased Handyman Connection out from FirstService Brands at the end of 2013. So I also own the business as well.
It seems that FirstService Brands has created quite a speaker pool for you, Scott.
Yes, yeah, they require us to be available for the rest of our lives on these things.
Yeah, well, I mean, it's amazing that so many people have that legacy to start with, and says something about that company and the people that it associated with.
Mm-hmm.
All right, great. Well, thank you. Thanks for joining us. Joe Lindemeyer, also known as Lindy for this call.
Yeah, one Joe is plenty for the call, I think. But hey, everybody, I'm Joe Lindemeyer. Sorry, my video isn't cooperating right now, but I am the current multi-unit owner of California Closets along the Gulf Coast out of New Orleans, and we spread over into Panama City. And I started franchising in 1993 and owned the company, started another brand, had some fun with that, and just have kind of lived on both sides of the railroad tracks when it comes to franchisors and franchisees, and had some fun with international stuff along the way as well. And yeah, just happy to be here.
All right, man. Thank you for joining us. I appreciate your time today very much. All right, so let's get right into the meat of it. So we're talking about employees versus independent contractors. Jeff, help me. Why do people? What's the issue here? Why does it matter?
You had me at help me, Lane. You're the lawyer. That's usually my call to you guys. So when you talk independent versus employee, first of all, I think there's a couple things. One is where you're located. I think everybody knows that California is its own entity.
Well, wait, let me ask that question just a little bit differently. I'm trying to do the setup. So if you're a company and you have an opportunity to set up your workforce, and you can set it up as an independent contractor, group of independent contractors, or as a group of employees, I'm sort of like trying to get on the business side. Like, what's the difference? And maybe it's a better question for you, Lindy, but what's the difference and why do people choose one over the other in a vacuum for business reasons? Forget about the law.
Joe Lindemeyer, I'll throw it to you then.
Yeah, it's funny, Lane. I think certain models that are probably participating in this session, as well as ones that are thinking of future brands, have ways that they just have always done it. And so I think one of the difficulties in reinventing yourself is considering the pros and cons of what you would do differently if you were on the other model. I think as we've looked at expansion opportunities, we're a full employee model. We do that for a number of reasons, and I can go into some of that, but we have considered what it would look like to have an independent contractor or a bit of an outsourced model, if you will. And, there's just not a way for us to do it halfway both ways. So we've kind of been fully dedicated to the all employee model. But not to say that if we were to reinvent ourselves, we couldn't do it the other way. We would just have to change some of the things that we've done.
Okay, that's interesting. Joe, Dunn, do you have anything to add?
No, I think that this is increasingly an issue, particularly the misclassification claims with independent contractors for franchisors whose system is set up that the franchisees use independent contractors rather than their own employees. We see that more often in the home services industry than, say, a retail McDonald's, where there's no question that the person at the register is actually an employee of the franchisee. And AB5 in California is trying to, the fear is that you follow the employment line, not from the worker to the franchisee, but then from the franchisee to the franchisor. And those claims, in my view, are more likely to be made if the individual doing the job on behalf of the franchisee is an independent contractor rather than an employee. Because when something bad happens, they follow the lineup. So even in the more recent McDonald's case in California, which claimed to follow the Dynamex case on independent contractors, there found that it was consistent, and in that case fine, because it was clear that the employee was an employee of the franchisee. I think when you're using independent contractors, particularly in a state like California or others that use the ABC test of, are they free from control? Are they customarily engaged in something that's usually done by an independent contractor, like a one-off thing? And is it separate from the underlying business? And if they're not, they maybe have a misclassification claim, which means somebody gets hurt or they file for unemployment, and you can, all of a sudden somebody's looking at your wage and hour, and if you withheld, and the state gets involved. And then plaintiffs' attorneys use that to try and hold franchisors or franchisees liable for all sorts of torts. I'll just also say that these questions, as they become more top of mind in California and other states like that, and perhaps federally with the new administration, that in my transactions that I do representing buyers and sellers of franchise business to private equities or strategic buyers, this is becoming much more important in the due diligence process to make sure you're tight on these things and have stayed in your lane, if you will, and modeled your system in a way that will withstand scrutiny, both if you're trying to sell or get an investment. Your potential investor or buyer is going to look at that. And if you're a buyer looking at a potential target, it's certainly something you're asking about.
So Lane, do you want, from a franchisor perspective, just a few thoughts on this as well?
Yeah, absolutely.
So Joe gave a great in-depth analysis, and he also mentioned two different things: these storefronts versus in the home services. So let me go backwards and say, as a franchisor, I'm agnostic towards what you run as a franchisee. Okay, I ask that you follow the law. Clearly, when we're talking about stores and we're talking about the word control, if you have an employee or a person who's going to show up from X time to Y time, and they have no control over pricing, et cetera, it's easier that more falls into an employee model. As a franchisor, we are agnostic, and we actually run both, and some of our franchisees run both employees and independents. And I think that goes to probably a much more complicated one, which is who's controlling the pricing. What is that person capable of? Do they have the licensing to run as an independent? What state are they in, or what location are they in? And what's the franchisee's preference? So it's a lot more complicated, I think, probably in the home services sector than just maybe a storefront.
I think that's right. All right. Want to talk a little about joint employer, Joe?
Yeah, I mean, the question of joint employment is one of when is it reasonable to hold somebody else liable for the employment conditions of a worker. And, there's this movement to try and hold franchisors liable for the acts and omissions of the franchisee and how they treat HR and wage and hour. And again, I think misclassification claims are a thin edge of the wedge that opens that up. But so, you see this issue more prominently in California, but I also think that you're going to see it again federally with the Obama administration, in that the Biden administration is people from the Obama administration moved back to their old offices. Sorry about that, at the Department of Labor and the National Labor Relations Board. So I suspect that the NLRB, which deals with unionization, that we're going to see a return to the Browning First decision that sort of expanded the definition of who an employer was, not just the one to control, but sort of a more holistic view of what the working conditions are and whether or not a party reserves the right to exercise some control. And even ambiguous sort of touch points of potential control are things that the NRLB in that decision said that they would look at. And so sort of ambiguous operations manuals, that what's required versus what's a suggestion, particularly as it relates to how the work is performed, is something that I think from an NRB perspective is going to get, legs again. But that's really a question of unionization. And again, mostly I think for larger systems like McDonald's in the crosshairs of some of these people. But the Department of Labor itself, in the waning days of the Obama administration, revisited its definition of an employer and went from sort of the traditional control analysis to an economics reality test, which has like all sorts of potential test points, from directing, controlling the work performed, the employment conditions, the repetitive nature of the task, how integral it is to the business. In other words, is it what the business is, or is it merely the cleaning crew that comes and, cleans the office at the end of the night? That may be different than, independent contractors or workers that are working in the core element of the business, and who performs what administrative tasks and aspects like that. So the Department of Labor, at least back then, 4 years ago, was saying, look, it's not a question of you're heavy all in one, although that may be enough to tip the scales, but you could also lightly touch 6 of these factors and the collective weight moves the scales. So, as those kind of opinions are likely to sort of fall out from the Department of Labor over the next couple of years. What you're going to see is it follow from various states like California, where already, I think what we're going to see replicated federally, to plaintiffs' attorneys, and not just on wage and hour and harassment or other employment conditions, but also using the joint employment issue to be the piece to hold franchisors liable for the acts of omissions of their franchisees, just because they're deep pockets. And historically, if something happened on a job site, whether it's a theft at somebody's home or an injury or to someone, car accident even on the way to the job, the issue would be, well, that's the franchisee's responsibility. Now, if these decisions come the way we're sort of predicting, it's going to be much harder for the franchisor to get out of them at first blush. And, so you're going to have to seek indemnification and make sure you're well insured on those issues.
So this feels like a little deja vu, right? Because at the end of the Obama administration, we were talking about this, right? So and Jeff and Lindy were both franchisors then. And I wonder, because we talked about people sanitizing their manuals and other things for those type of affirmative obligations, particularly in the home service business. So is it deja vu? Is this exactly the exercise we went through just a couple years ago? Joe Dunn?
Yeah, I certainly think so. When this first came up, we went to all of our clients. We sort of had a joint employment test evaluation. What do you get involved with and what don't you get involved with HR in particular issues of your franchisees? Do you have applications? Do you take applications for your franchisees' employees? Do you set the working conditions? Do you sit in on interviews? And, those kinds of things that may move the needle on the Geiger counter when somebody comes and does a test on your system. And we scrubbed operations manuals for things that were mandatory versus recommendations that weren't brand specific, mostly relating to HR issues and things like that. And so people then got lazy over the last 4 years, and I think it's a good opportunity to go and revisit those issues again. At the end of the day, franchisees are independently owned and operated businesses, and franchisors have an interest in making sure they follow the system and display the marks and, do those things that are brand specific. But, how they handle their workforce and what they pay them and what they call them and, compliance issues like that are and should be the franchisee's domain.
What about this big company? I'm sorry, that recruit operators or technicians for their individual businesses as a practice that's gone on probably for 20 years.
Yeah, and there's business reasons why franchisors will do that, but I think that one, you should think long and hard about whether or not that's something that's really required, and if you want to, and if it is, you need to make really sure that your ads or your posting on your websites state exactly who their employer is going to be. And it may not be the franchisor. And particularly it's, disclaimers that your employer is going to be some independently owned and operated business. And the application should be that way. And when you get through the interview process, it should be with the franchisee. And they need to make sure that, they understand who their employer is going to be. And that, we're not sitting in on interviews or giving clues or indications that they're going to be working for us, the franchisor.
So let me ask Jeff, did you make some changes to your manuals and things back in the day, or are you?
I think that the challenge that you have is as a franchisor, you're running most of us are running 10-year plus franchise agreements. And to sit there and go, how do I put in black and white a 10-year document that's able to move when the game changes? Because 10 years, you're going to most likely have a change in administrations, a change in policy. So how do you best straddle that line? And so yes, we've clearly come up with language that tries to walk the line and being able to go, which side of the line do we want to argue which day? I think that at times that if you're running as I said, our franchisees, we're agnostic as a franchisor, but our franchisees will choose either one. I think that if you have a little bit of gray area, you probably are able to play both the sides of the lines a little bit easier. With that being said, at times it's probably easier if you just decide to choose one path, right? If you're, if you choose the employee path, and Joe Lindemeyer might be able to speak a little bit more about this, but we've certainly changed the FDD over the years, and continue to do so based on our attorney's recommendation.
Well, and just add, so the FDD, the franchise agreement is a 10-year deal. And so Jeff's right. It's hard to change that for somebody that's been in the system 8 years. And, but we can change things going forward. And more importantly, take a look at the ops manual. And not only does it need to be scrubbed and make sure there's recommendations versus things that are required in the HR issue, but the facts on the ground have to match what the agreement says. If we say it's all recommendation, but we're in there making it mandatory as a matter of practice with your field staff or your, operations folks, that's going to be a problem. And so there's some training and understanding where your lanes are and where the lines are to stay in your lane, and, a scrubbing of the ops manual that you can change from time to time and not have to wait 10 years.
Well, Lane, and you know this from all the years that we've worked together, and Jeff, on every side of this angle, as well as, as a franchisor, you want to stay current to things. And again, you got that, whether it's a 10-year agreement and opportunities of renewal. But I know just even recently dealing with what's been happening through the pandemic, there's been franchisors that have looked at making addendums to their franchise agreement based on certain PPE or certain things. And if this is the flavor of the election cycle, that's what I would be concerned about as a franchisee, that franchisors make wholesale changes to franchise agreements or look to that. And Joe, you make a great point about the ops manual, right? There's not many franchisees that look at that ops manual after they go ahead and get it done. But if there's going to be some updating and changes to that, definitely involve the FAC, figure out some ways that this is going to be helpful in a environment that whether it's the joint employer, whether it's some other, hot topic that's happening, there's obviously going to be some federal guidelines, but there's some other these topics that have some state requirements that are part of this too, that, may, cause some challenges for the franchisees as well as the franchisor. But, this is one of the things that I think, being on the franchise side of it now and having, the structure of the business that we've got with all of our direct employees, working with the franchisor and making sure that we're in tight communication around this, so that we're not trying to anticipate what the government's going to do, because as we see, we're just a few days into this and we're already changing things that we've been operating under for the last 3 years, and there's more coming.
Yeah, I agree with all that. I would take issue with the idea that people may have that we're changing because of the administration. I think that this has always been true. This joint employment question to me is the flip side of the same coin on vicarious liability. When's it reasonable to hold the franchisor liable for the acts and omissions of the franchisees? So a lot of this is what should have been best practices, that there are some things that are specified and required because of the brand, and
right,
some that are the franchisee's responsibility, frankly. And, the trap is that franchisors, in an effort to get, business, or to, more importantly, to be helpful to their franchisees, sort of overstep those bounds, and, no good deed goes unpunished. And so I sort of view it as going back to how things should be structured. And again, the ops manual is important, whether Joe reads it every day or not, because it's going to be evidence in the case. It's going to be a question: what do your documents say? And do they say the right things that exculpate you from liability or put you in the, crosshairs? And then you have to overlay it with the actual facts. Did you actually get involved in the HR decisions despite the manual saying otherwise? That may be a different question. But, I think a lot of this is just best practices, and it's a useful reminder that, we need to, franchisors need to stay in their lanes in certain things. And what happened federally, look, it takes the pressure off, but these are always going to be issues in certain states like California and Washington, for example.
All right, let me put a push pin in this issue. Let's go on to another issue. Joe, start us off with, I want to talk a little about material changes and unique registration issues, and maybe unique being perhaps not as pronounced as they are with others, but for service-based franchisors. you speak a little about the material change issues and how that's come up and how that's slowed down people's registrations?
Yeah, you always have an obligation under the FTC rule to amend your FDD upon a material change. The pandemic has resulted in numerous material changes to people's franchise agreements and offers, and more importantly, the initial investments, for example. So if you've changed your model to account for different aspects of the pandemic, you have to look and see, what do I need to change in the FDD or the franchise agreement? Maybe it's the initial investment, as Joe talked with, PPE or, other requirements and costs. It may throw your item 7 numbers off. And if you have additional requirements that you're going to carry forward, you need to look at that. Is it material, and then amend the document? And more importantly, maybe the item 19 in the financial performance representation that, you have an obligation to amend immediately if there's a material change to your FPR. And in June, the state examiner umbrella organization came out and essentially said, look, don't forget about that. And frankly, what started happening from the summer on was they started asking specifically, what's your 2020 results in the pandemic versus what you were presenting in last year's FDD, the 2019 results. And, requiring franchisors to demonstrate that those numbers were reasonable to keep in, i.e. that your system was meeting or exceeding those results. And if there was some deterioration in those results, requiring you to put 2020 numbers in. The good news, I think, is a lot of the home service industry did well in the pandemic, even or up after, maybe the complete lockdown in April and May. So that may be easier for this group to handle than it is was for some of our clients. And what we're finding now, in that we're doing some early renewals with the 2021 update, is that examiners are asking those questions again. And if your 2020 numbers aren't equal or materially the same or better than what they saw in last year's FDD and you didn't amend, that's going to be an issue getting registered. And if you're using 2020 numbers without including the 2019 numbers this year, they're asking those questions. So there may be some delays there, and you should be prepared to answer those questions, that how your performance in 2020 stacked up as the 2019, and what changes you've made to the system that may need to get picked up in either item 7 or elsewhere in the document.
For home mobile service brands, it's really been more the comeback story, right? It's how it fared in 2020, if it was closed or not closed for any period of time, and then what it's like in 2021. And I think people are going to be presenting real time, as close to the minute that they're filing numbers that they can, because that's the only way you can talk about it. If you don't have 2021 numbers in your FDD, you can't say we're 10% ahead or back or down or same store sales or this. You can't. All those numbers need to find their home in the FDD, and people need to incorporate them so that they can then be able to share them. And I don't think people will be amending every month, but I think as the comeback matures and as people achieve and then surpass their prior numbers, that's the economic advantage that they'll want to get out there. I think there's great stories to tell in item 19 now, especially that you're trying to get through the pandemic. I think the point is you probably have to get a lot more recent in terms of what you're reporting, especially if that's what you're going to be talking about.
Yeah, and there's no rule that says it has to be a calendar year basis. You can go last 12 months and try and pick up January and February and file in March or April. Get the latest numbers you can in there. Or you can demonstrate, month to month 2019 versus 2020, where it shows that growth in the home services industry during the pandemic if you did well on it. Lots of different ways you can present the data to make a more compelling case.
How much latitude do you have to stratify it by trying to isolate the ones that were least affected by the ones that were most affected or most closed, maybe to use a more black and white type?
Depending on the size of your system, you're allowed to create subsets once you have more than 10 units. So you could start to break them out by region if there was an impact there from, units in the Southeast and stuff that may have been open more than, say, New England and New York area. Alternatively, the law provides you to give a supplemental financial performance representation. It can't go beyond what's in the item 19, but you can drill it down more geographically. And, so maybe you don't want to, break it out geographically for everybody, but if you have a prospect in the Southeast where they were open more often and your results are better than they are on average, then you can take just the Southeast units and present them in a supplemental. It has to be in writing, has to have the same bells and whistles as the item 19 itself has. But there's creative ways you can try and present your best data to your prospects.
Well, to identify more lucrative geography than perhaps buckshotting the whole country based on where you have registration issues, where you have poor performance. Lindy, how happy are you that you don't have to deal with this anymore?
It's a shame you guys can't see the smile on my face on the video right now, but yeah.
You remember, is it giving you a bad taste? Like indigestion? You want to go take a Zantac or something?
Nah, you guys you're on it. You're the calming force to it.
All right. So in addition to these other unique registration issues that have come around through the closures and through the pandemic, we were also, Joe, a year ago talking about revenue recognition. I know, Jeff, you're a passionate soul on revenue recognition. You want to start us off before we let Joe put the sinker on it?
That's me saying I hate it. It's dumb. I've been surprised on how much work has gone into this. And Lane, I know you've been a big part of this, and Joe's been a big part of this with the IFA. The amount of time, effort, and energy the IFA has put forth on working on this has been amazing. It's been shocking to me as far as from a franchisor perspective, how many franchisors didn't fully understand what this was going to do to them. And even when we were together back in March at Unconference, to find out how many people just kind of rolled over and took the straight line, depreciation or straight line revenue. Yeah, so that's been surprising. With all that being said, I know that the Financial Accounting Standards Board, or FASB, recently has come out with new rulings over the last couple of weeks as far as a more standardized revenue recognition. I still think it's a tremendous pain in the butt. I can tell you I'm not an accountant, but I somewhat understand our financials, and I'm still confused as to how we represent these things. I can tell you that if you're a franchisor, if you have not been dealing with this with your accounting firm, I would hope that you engage with them quickly and make sure that, number one, they understand it and they fully understand what you're trying to do. We worked very hard to be able to recognize as much revenue as we have. And I think we were one of the higher ones. Lane, or Joe, you may or may not. I think we're recognizing close to 84% of our revenue in year one, right after training.
Okay, so I would tell you that's extraordinary and at the very high end. And
yeah.
So if anyone on the call isn't at that level, they should maybe go revisit it. It may be partially the accountant of choice. Joe can speak a little to the diversity among accountant views on this last year before there was a little more direction. If I interrupted you, Jeff, go ahead.
No. Look, and again, don't call me on this, right? where I go, there was a lot of education that took place. We worked with our accounting company for a couple years to be able to discuss this and work with with FisherZucker and also then our accounting company to be able to say why we were able to recognize as much revenue as we were. So it's a bit of a moving target. I'm not sure with the new FASB ruling if that's going to slip away a little bit, but it's a pain in the butt. Joe,
tell us about that new FASB ruling.
Yeah, so I think good news, Jeff, is I don't think it'll affect your results. So when the income recognition rule came out, what FASB was trying to do was more, in our view, accurately describe revenue from an IP license. And I sort of liken it that they're aiming for the software licenses. And because a franchise agreement's an IP license and a trademark license, it sort of got caught up into it. And so essentially what they're saying is the initial fee is payment for access to the IP, and therefore it should be straight lined over time in terms of recognition. So if it's a $10,000 fee in a 10-year agreement, you're recognizing $1,000 a year. But they did say, look, if there's a distinct performance obligation that a franchisor has, independent of the trademark, in other words, it has value outside of the system, then you can recognize it when the obligation's complete. And so some accountants in their audit committees determined that the appropriate interpretation of that was everything's associated with the IP, so every dollar has to be amortized over the life of the agreement. Other accountants engaged in the process that Jeff did and looked at the distinct performance obligations that a franchisor has before opening, training, site selection, those kinds of things, and would properly recognize some of that as being revenue that should be recognized upon completion. So when Jeff does the training has a value of, say, $100. 80 of it is stuff that's useful outside the market. It's QuickBooks. It's how to run a business. It has nothing to do with the specific Handyman IP. And so his accountant said, okay, you can recognize 80 of that 100 when the unit opens. And so that's a process he sort of had to go through. And it led to all sorts of disparate results, with some accountants being far more conservative than others that wouldn't even entertain the discussion that there was something distinct from the IP in a franchise context. So the IFA and the committees that I served on dealt with FASB for several years now, and they just last week approved the final form of what they call a practical expedient, and that is for private franchisors, doesn't affect public companies. They have to fulfill the whole rule. That gives a private franchisor the option to either go through the full process Jeff did and work out what number you get, or it allows you to pick from sort of a pre-selected list of obligations that the FASB has agreed is distinct. So site selection, training, things like that. That if you choose that expedient, you don't necessarily have to go through the full process, but what you still have to do is put a value on that the auditor would verify. So it doesn't do away with part 2 of that sort of analysis, which is the hard part that Jeff bemoans. But it does, at least from my perspective, make those conversations a lot easier with the accountants, that there are in fact some obligations that are, reasonable to have your income recognized when you complete them. So I think it's a large improvement from, and will bring some uniformity to how franchisors compare it. Because, what happened last year was somebody like Jeff got 80%, other people got none, and yet they're identical businesses and just two different accountants coming to two different conclusions.
Yeah, I would encourage you to inquire of your accountant before your audit is issued to understand how much of the initial fee as a percentage, as Jeff just expressed it, you can look forward to recognizing. And if it's 0 or some remarkably low number, you can certainly call one of us. We'll try to give you some coaching. But you don't want to, once that report gets issued, it can't be taken back and it can't be reissued. So it is really important to understand where you stand. And at least much of Joe's life last year was consumed in trying to provide some context to accountants as to what other accountants were doing in other contexts and in other brands. I want to go to a question.
Can I add one other thing? I'm sorry. Just because it's FDD time, one of the things that we were able to rely on in doing that was what's in your FDD, what's listed in your item 11, what is your pre-opening obligations. So the more you say you are doing for the value of that franchise fee, and the more you are saying you are not doing, that helped in our justification of basically we are telling you we are giving you everything we have for the franchise fee. So the more you can help out or put that kind of stuff in your FDD and working with your attorneys on what's in your FDD and what's in your FA, your pre-opening obligations, that helped. Back to you.
And you want to look at like the training chart and how it's described to try and write it in a way that's more likely to get some recognition. Now, the good part is, again, that, the expedient, if you adopt it, should circuit some of that discussion, but you're still going to have to put a value on it.
Joe, how does it work for multi-unit? So if I do a development agreement,
it depends which accountant you ask, but for the most part, what I was saying is that multi-unit is entirely for access to the IP. So if, and you would begin recognizing that portion that was allocated to future units when those agreements are signed, and that would begin, say, that 10-year amortization period on recognition. But there may be some, unique reasons why that could be different in any particular case. But, so selling the 10-pack was having, a devastating effect on the balance sheet of certain audits. Now, and don't forget, tax accounting is entirely different. You owe the money on that to Uncle Sam. You're just not recognizing it for the audit purposes for years, which of course turns your audit upside down when you go to the registration states and impound requirements and things like that.
So just a further complication in, let's say, California, when you go with your differing item 19, now less equity, presumably, maybe that started last year, than you had in the prior years in terms of recognition. I want to just take a look at one question in the Q&A, and it asked whether there's a technology system which processes activity between Azure and Z, and would that change whether workers are viewed as an employee versus contractor? Does it matter whether they use a technology platform, whether they're an employee, Jeff, or an independent contractor?
We have a technology platform. Look, let me back up and say I'm not the lawyer here, so anything I'm saying you throw out the window, because I'm not giving legal advice. With that being said, and Joe spoke about this, and this is part of the scary thing in the gray area. Unfortunately, and Jill, please correct me if I'm wrong here, there's not guidance anywhere that says if you hit X number of these things, because they're weighed differently, that says if you require somebody to use your technology platform, that doesn't make them an employee or an independent. It is a number of things that exert an overall picture of control. So to my experience, no, asking independent contractors to use a technology platform in and by itself does not move them over to employee. That can be one of the factors that Joe would be able to speak about, as far as to say, if you require them to use the technology and wear the uniform and show up at a specific time and do these specific things and price this specific, those are a part of it. But just using a technology platform in and by itself is not, to my knowledge, does not kick you over to being an employee.
I think that's
and I think it matters these things are all very factual specific, fact specific. So Jeff's right, it's one element people look at, but it's also a question of what does the franchisor require of the franchisee with that technology? Is it just for the franchisee scheduling purposes of their own employees, but does the franchisor monitor that in real time, or does the ops manual require them to do certain things like this is the time to send people home because there's not enough customers, or this is the time you need to, keep people in overtime? And is it a suggestion or is it mandatory? Those are the kind of facts that'll drive the conclusion in these cases.
So let me jump in. Joe, let me give Lindy the last word here. There's a couple minutes left. Joe, so now you're a franchisee. Tell us about PPE. Not that you have lots of hand sanitizer. That's interesting, but not that interesting. Tell me about, how you still get into people's homes, what the PPE protocol is. Do you have them sign anything terrorizing, releasing you in order to enter their home? What are you doing?
Yeah, well, and look, talk about moving targets, right? This is all over the place. And first of all, we set an expectation to the clients before they even contact us on how seriously we take this, what our expectations and protocols are. We are going to abide by the CDC requirements. We're going to abide by all state and local regulations. Our franchisor is a California-based franchisor, so they're probably erring on the side of more strict measures than other parts of the country are. But you also have the human element too, right? With our employees, there's some of them that have their own opinions on it. We had to have a real good conversation around the fact that, look, you can have your own opinions outside of work hours, but when here's what our expectations are. And, we're going to wear masks. We're going to abide by all the guidelines and regulations. And for our clients, what's interesting, we're along the Gulf Coast. New Orleans was kind of one of the early spikes to this whole thing. But people are sick of it. They will tell our team members sometimes, hey, you don't have to worry about wearing a mask. Don't worry about this. Don't worry about that. And the team members have gotten very good at saying, you know what, I don't mind. It's okay. And they'll even say to the customers now, I've gotten so used to it. It's been a year, and it kind of takes that part of it away, that discomfort. But where a client might have COVID, or they're sick, or there's some of our staff members that have been sick, we go super cautious on that, and we'll send that employee home. We'll do the protocols to have them get tested immediately, contract trace within the team. It's just not worth it to have the business take a bigger risk and get shut down for a longer period of time. But on top of that, it lets the other employees know that, hey, they do care about our safety. And who knows what the next month's going to call for, but that's kind of how we're handling it now.
Are you getting anything signed when you enter someone's house?
What? Sorry, Lander, are we getting any what?
Anything signed by a patron? I was second one second. Anything?
No, we don't have them sign anything. And when they come into the showroom, there's signage out of what their expectations are when they actually come into our showrooms. We've got a handful of showrooms, but our contract. And I know one of the questions we talked about in prep for this was around force majeure and whether we're going to call it out in our contracts. And, just personally, I'll share that we have a cancellation clause inside of 2 weeks, and we've had a number of people that have been affected by that inside that time frame, and we've not invoked that cancellation clause once. It's the human element part of it. You and Joe could tell me if that's defensible or not if we ever wanted to, but right now I'm not going after that.
All right, I think Scott's here trying to take the.
No, you guys have done great. Lane, thank you so much. Joe, Jeff, and Joe, you guys have done a great job. I just want to just put a plug in here. I've attended a bunch of different conferences. At the unconference, Lane brought up the issue around revenue recognition. And sure enough, our business saw that happen in California. We went in with our audits and we got all kinds of comment letters back from California. The joint employer issues, I was personally affected by something that happened in 2015 where our contractor fell off the ladder of a franchisee and then we get sued. And so these are really important issues that we face as home service franchisors that we wanted to talk about. Yeah, and of course, Joe and Lane are great to get in contact with if you've got more questions. Thank you again, guys. And at the end of this session here on the closeout, you can just go to the lounge if you'd like, and you can do any one-on-one sessions with people who have spoken here with us. And thanks for joining us. Great job, and we'll see you again soon.
Thank you so
Thanks,
much.
guys.
Thanks, Scott.